I just want to mention at the outset, because I didn't do it very much earlier, you've got our Twitter handle on the brochure. I hope you'll use it. It's FSF CONF 8. You know, a lot of you weren't here this morning when I got started, and I said, when I woke up this morning and I told my wife, I said, my God, I can't believe it's our 8th annual conference. I mean, I guess time really does fly when you're having fun or when you're busy, but this is the 8th annual conference.
That's great. Congratulations.
So thank you so much for being here. I appreciate it. I should say John and I were just outside, and I apologize to him. I said a little bit earlier that I'm recovering from a bit of a cold, so I might sound nasal, and John told me that he's got allergies, and that he might.
We thought we might make this into a sniffle-thon. Right,
we might do that. But I was thinking, see, mine are not allergies. I think it might be some bug. So, you know, I'll just say that if you're not really responsive, then I'll lean over and breathe on you. But if not, no, I'm just kidding. I'm not going to do that. The other thing we've said all along is we're just doing the very brief version of the bios because you've got those in the materials. But all of you know John is General Counsel of the FCC. Previously, he was a partner at least three very distinguished law firms. And in 2008, he served on President Obama's transition team for technology and economic development at the Department of Commerce. He also, by the way, was a law clerk to Supreme Court Justice Powell, and that may be relevant later when we start delving into what the rule of law means and so forth. So, John, I'll just say that, you know, I've been fortunate that we've had a number of what I consider to be distinguished guests at this, what we call the lunchtime conversation, and some of them have been here, the FCC commissioners that were here earlier, and other FCC commissioners. Last year it was House Majority Leader Steve Scalise, and I think he's 4th in line or something like that, you know, to the succession after the presidency. But, you know, when people found out that you were going to be here, they told me that you were probably number 2 in line over to the succession at the FCC.
I think that's not right.
All right. Well, maybe that's Phil Verveer who's over there.
There's nobody more distinguished at the commission than Ambassador Verveer.
Ambassador Verveer, and so. But anyway, I'm really I'm glad you're here.
Yeah, thank you.
I'm going to start off with some questions that are maybe a bit personal, only in the sense of relating to your job. So tell me what job that you've had in the past that you think best prepared you for the general counsel's job.
So can I got to give you more than one because I can't get it to one. But the first 3 jobs I had after graduating from law school, which is now a long time ago, I was a law clerk for Judge Edward Tam on the D.C. Circuit, a law clerk to Lewis Powell, then an associate justice to the Supreme Court. And I went to work at the firm Miller Cassidy for Jack Miller. And I think I learned from those 3 men lessons that have endured for a long time. And I'll tell you about each of them quickly. Judge Tam was on the D.C. Circuit. He was a former FBI agent. I will tell you one story. I was walking through the chambers one day, and I noticed this little framed letter on the back of a room, a little interior room, that I'd never noticed before. And I walked over, and it was a thank you letter to Edward Tam from J. Edgar Hoover, thanking him for his help in solving the Lindbergh kidnapping. He was the only person I'd known who was involved in solving the Lindbergh kidnapping. And he had perhaps because of his FBI background, a very practical sense of the law. And that was, I think, very useful. Lewis Powell was just a wonderful man, right? People talk about why Supreme Court clerkships are prestigious or something. I don't know, but the chance to work for him as a man was extraordinary. He was a guy who had been head of the ABA, who had been very active in Richmond, where he had practiced law till age 65 when he was appointed to the court, and very important in the days during the 1950s in keeping the Richmond school system open at a time when that was in question in the wake of Brown versus Board of Education. Had come to the court with a wealth of experience, and we'll talk more about this, but he had a very, very distinct notion of the importance of facts and judging each case on its own terms. And I'll just tell you one thing. He was a very reserved, courtly Southerner, and I'm an introvert. So the day I went for my interview with him, and it's, Supreme Court chamber is a very intimidating place. There was not a lot being said between us until he raised the one topic on which we were both enthusiastic, and that was Ted Williams and the Boston Red Sox. And then Jack Miller, for those who don't remember, Jack was a Republican who served as head of the criminal division under Bobby Kennedy in the Justice Department, and then achieved renown some years later when he represented Richard Nixon in the negotiation of Nixon's pardon. Right? Not everybody had been so associated with the Kennedys and Nixon. And I tell you what, I went to work for him as a young lawyer, and this I think about a lot in terms of the Office of General Counsel. Look, everybody knows the junior lawyers are there to help the more senior lawyers, but what Jack felt very strongly was that the obligation was reciprocal. And I remember one day he was forcing me to go to a hearing in Houston to cross-examine the chief judge of the district court, and I was, to put it mildly, extremely nervous about this. And a knock on my door about 5 a.m. before the hearing, and he comes in, and he sits down, and he walks me through the examination. In other words, in many ways, he taught me that it wasn't just my job to help him, but it was his job to help me in my career. And I think these lessons, to be practical, to focus on facts, and remember always one's reciprocal obligations, I think these have stayed with me a long time.
Good. I might be wrong about this, but I think Nate Lewin was at that firm, and
yes.
he's someone that I admired. We don't have time to really go into it, but he was a great lawyer and especially interested in issues of relating to religious freedom that I followed, and I always had great respect for him.
He's a great lawyer, and he and I represented Jodie Foster. Wow. In connection with the Hinckley trial, the Reagan assassination attempt. And when I worked for him, I've never seen anybody write an appellate brief the way he does. It's just extraordinary. Okay,
I mean, you touched on this maybe just a little bit, and this time I'm going to hold you to the one. You see, I've got it in caps here.
I appreciate that.
So what is the one personal characteristic that you possess, not your professional experience that you recited some of that, but that you think is most important in doing your job well?
So I can't overemphasize how uncomfortable that question makes me, right? Because I'm a shy New Englander, and the idea of talking about myself in this way is difficult.
Well, you're among just a small group of friends here.
So I asked my chief of staff, Jennifer Tatel, who does a great job, what she thought the answer to this question was, because you gave me a heads up on this one, and she said humility, which I hope is true, but I would say it this way. I think it's gratitude. I am very grateful for this opportunity, right? Opportunity comes along perhaps less often than one thinks in life, or might think when one is young. I'm very grateful that I have this opportunity, grateful to the chairman and the commissioners to be in government again. And I gotta say, continually grateful to the lawyers in OGC. You know them, right? I mean, people who've dedicated their careers, their professions, to focusing on the law and improving the work of the commission. And I'm extremely appreciative every day for what they do.
Yeah, no, I do. I was fortunate to be able to serve in the General Counsel's office back in the late 70s. And I mean, just the one thing I'll say, I think you were alluding to this, some of the people in the GC's office who were top-notch lawyers, such good lawyers, they stayed for decades, really,
That's
in
right.
that position, and I think it made it a special place
Yeah.
to work, really. Now, so speaking about the role of the general counsel's office, look, if we're honest, again, we're just among friends here. If they're different, with different general counsels, I think, can view the role somewhat differently. You're obviously the chief legal officer for the commission, but the general counsel that I happen to serve under, he was very interested in policy as well as legal issues, and he was involved in a lot of the policy. I want you to help people here understand how you view your role as general counsel, and specifically sort of address the extent to which you've been involved, want to be involved, and are involved in what we would all agree are sort of the more pure policy-making aspects of what the commission does.
Sure, I've talked to other general counsels, past general counsels, and I think there is a tradition of general counsels who play a counselor role as part of their function. I think it goes to the three critical functions of the office, which I think of as this way. The general counsel's office is available as counselors to the chairman. The chairman is the CEO of the agency under Section 5 of the Communications Act. And to the extent that the chairman wants views, then OGC makes them available. The second function, which is critical, is that any commissioner gets unvarnished legal advice from the general counsel's office anytime the commissioner wants it. And thirdly, that when the commission makes a decision, a majority reaches a decision, it's really important that the general counsel's office represent the commission. In other words, every once in a while, even the chairman will be in a minority. I think this happened in the early part of the century a couple of times. If that's what happens, if the chairman's in the minority, then the obligation of the general counsel's office is to represent the commission, the majority view. I think those are the critical functions that the office plays.
Well, I want to say, in regard to the last one, and we're going to get a little more into the open internet order later, but I was at that oral argument. Thank God the decision didn't come down today, because everyone would be reading it. But I told you this afterwards. I have a different position than the one the commission ultimately took, but I thought you did a especially able job in arguing that case.
Yeah, I appreciate
really, I know
it.
it's not easy to do that. Just in terms of, I was thinking of something while you were giving that last answer about my experience that in the general counsel's office, that I can always get somewhat of a chuckle about it. It may be different now, but when I was there, under the commission's rules, or maybe it was tradition, the general counsel had to actually sign off on decisions that were made or actions that were taken relating to political broadcasting, like equal time or whatever. It was, I think, in the rules, and Phil would remember, there was the gentleman, Bill Ray and Milton Gross, and some real career people that have been there a long time, but GC would have to sign off on those, and I was up as associate general counsel then, but it was kind of interesting to me, and the deputy general counsel at the time, and he shall go nameless. It was just I found it interesting. We got a lot of those. So during election season, you get a lot of these things coming up. Is there a violation or not? And he would frequently sign these things in the space that was put there for the general counsel. He would write "signed but not read." Do you do that for any? You do any signed but not read?
It had not occurred to me that that was an alternative, so I appreciate the advice.
Yeah, I guess it worked, but anyway. Okay, now I have a question here, but I don't want it to be too open-ended, and then we're going to get. They're going to get a little tougher, right? I mean, this has been really softball, but I know there's
personal
nothing
characteristic one was tough.
I know there's nothing I can throw at you, but just can you give a couple of examples in which you as general counsel have played a more significant role than other proceedings in giving the chairman what most of us would consider to be, more purely policy advice rather than legal advice. And I hasten to add, I don't, think there's anything wrong with that, as I've intimated, but people would be interested in knowing, I bet.
Yeah, there is one area in which we've played a particular role with a historic basis, and that's in the review of some large mergers. So in 2000, when Chris Wright was the general counsel, the commission formed a transaction team in the office of general counsel. At that time, recruited Jim Bird from private practice, who still heads it, does a wonderful job, and created it as a place so that merger-related expertise, no matter what part of the agency it involved, were created in one place. And so OGC has played an important role in merger reviews. Chairman Wheeler has asked us in 3 large mergers to serve as the chair of the steering committee inside the commission. And in each instance, there's been a lawyer in OGC who runs the project day to day, and each of these instances, a lawyer who had previously worked at the Antitrust Division, the Department of Justice, which I think is very important. And so in these cases, we played a particular role as a facilitator. Now, the policy bureaus, of course, take the lead on policy questions. And the economists, there are wonderful economists inside the commission. And as one would expect in a transaction review, the economic analysis is very, very important, and we pay close attention to it as we put together the staff recommendation to go to the chairman and the commissioners. So this is a very particularized example.
Okay. I want to ask you to describe your legal philosophy or approach in resolving, a purely legal question. Put aside the policy aspect. There are different schools of thought that even have names associated with them. Textualists or living textualist or whatever. And by the way, I don't think you were here, but Commissioner O'Reilly and Commissioner Clyburn had a lively exchange this morning about how they approach, interpreting the Communications Act. They were talking about Section 629 in that instance. But I want you to talk about your approach, and then if you want to, you can lead into my next question or two, which relate to the rule of law. That's the FCC and the rule of law is our theme for this conference. And so talk about how what your philosophy is, and specifically how that relates to your understanding of what the rule of law means in the context of what the FCC does.
Yeah, so let me give you an overall sense. I've talked before about the experience of having worked for Lewis Powell, and to me, this is very important. In other words, Justice Powell had a particular way of looking at facts, of looking at circumstances, of looking at context as critically important. And he was not unique in the jurisprudence of the Supreme Court. I think Justice Holmes, Justice Brandeis, the second Justice Harlan had similar views. This is the way I was taught, and I have to say I believe that law ought to be applied. I remember one instance. What would happen is he would go to the conferences, right? And he would take notes. And then when he came back to the chambers, he would read his notes to us, right? Because we had to know, had he been assigned any opinions? Was he likely to be assigned any dissents? Occasionally he could be the senior justice and make an assignment himself. And we had a case, it was a criminal procedure case. And I felt pretty strongly about it. And I did something that was unusual for me, which was right before he went to conference. I went in one last time and explained to him my views. And he came back from conference, and he looked at me, and he said, "John, you got 4 votes, but not mine." And it was a good illustration of the influence, or limits thereof of a law clerk, but it was also an illustration of this was a very fact-bound criminal procedure case. And I offered him one reading of the facts, and he offered another reading of the facts. And that was the way he judged. And he knew it, right? He was conscious of it. He was, I believe he understood that as he was viewed on the court, he would be viewed differently than some of his brethren. At the time, Justice Brennan, and then Justice, before he became Chief Justice Rehnquist, who were seen as justices who had large overarching ideologies. And he understood that he wouldn't be seen in that way. But he really believed the job of a judge was to face the facts, and that law ought to be anchored in facts, and that didn't mean it wasn't important to reach important constitutional values, right? He was the fifth vote, one of the five in the majority in Roe versus Wade. But it did mean that he grounded in this. And I think a good illustration, one of my law school professors, now judge on the U.S. Court of Appeals for the Fourth Circuit, and also a Powell clerk, Judge Wilkinson. And he wrote a book last year, which I think is very interesting, and I hope people read, called Cosmic Constitutional Theory. And he talked about different kinds of constitutional theories. He talked about the importance of judicial restraint, understanding the role of judges. He talked about the importance of recognizing fundamental rights and what the process of doing so was. He talked about Holmes, Brandeis, Harlan, and Powell. And he came away, I think, with a conclusion that was not overarching, but was very practical and very common sense. And I hope people read this book, and I hope as you continue to think about these issues, you will as well, because I think it explains the art of judging in a very powerful way and in a tradition with which I'm proud to be associated.
Okay. I just earlier today, I guess maybe with the commissioners, when we were talking about the rule of law,
Yeah.
I just gave them what I think is a common definition, commonly accepted definition. I think you won't disagree, but it may impact some of our later discussion. I want to give you that and tell me if there's any part of it you disagree with. That the rule of law regime is a system of binding rules of sufficient clarity, predictability, and equal applicability adopted by a valid governing authority and applied by an independent authority. Is that a good definition of the rule of law?
I think those are all important concepts in the rule of law. I think there's more to the rule of law. And if I think there are different perspectives in the rule of law. Now, by the way, I appreciate having the chance to talk about this because I'm talking about stuff I don't get to every day, but I think is important to understanding our legal system.
You guys should talk about it more over there at the FCC
Well,
as you go along.
Maybe you should hear my answer, then you
All
can decide, right?
Okay.
Look, I think let me offer you 4 perspectives on the rule of law that
All
I think are important. One is the understanding that no person is above the law, right?
Right.
And Tom Bingham, the late Lord Chief Justice of the United Kingdom, has a very important book on rule of law where he talks about this, and he takes it back to the Magna Carta, right? And to the provision in the Magna Carta that says, to no one will we sell, to no one deny or delay right or justice. And this notion that everybody gets governed by the law and no one's apart from it has been traced by some scholars back to Aristotle. And I think it's a fundamental notion, and I think it finds voice, for example, in our Equal Protection Clause. A second meaning of the rule of law, and I've referenced Holmes in the past. I think Justice Holmes' understanding of the common law, his lectures on the common law in the book by that name, are incredibly important. And I've written in the past, and I believe, that the common law notion of precedent, of factual examination, is not only very important because it is our legal tradition, but it's well suited actually to times of dynamic innovation. Holmes says on page 1 of his book, The Common Law, he talks about history and he talks about statutes, and he talks about the combination of the two into new products at every stage, that's a quote, of legal development. And so I think common law reasoning is very important because I think it provides a way for the law to learn, which government institutions don't always do well. And then I want to do one more. Look, sometimes the rule of law just means there's a law and you have to follow it, right? There's scholars who look at ancient China and think that's what was going on. I don't know if people have seen the Francis Fukuyama book, The Origins of Political Order. It's a wonderful book, and he talks about development of the rule of law.
Are you going to get to a point where you recommend my book or just all these other books? That,
I was doing
yeah,
them.
no.
I was doing them in ascending order of
All right.
importance,
Oh,
so I
okay.
hadn't gotten to yours yet.
All right, go ahead.
Look, I
Wrap.
think, but I'll talk about your book. I mean, Randy and I had lunch a little while ago, and he was kind enough to let me get to a copy of his book. I think this question of copyright in the Constitution, constitutional values are very important, right? I think Randy's contribution to the scholarship is very important. I had understood that the first copyright was created by the first Congress, right? And we talked about that. But I hadn't sort of understood about its constitutional overtones. And as a way of stimulating innovation, it's really important. But I want to give you another history lesson.
All right, we're pretty quickly.
I know, but this one this is
Okay.
important. There's another notion of the rule of law that I think is sort of elemental to the U.S. So I'm going to go to ancient history now, but we all know in what's known as the Old Testament, the book of Deuteronomy, right? It comes up, it's the covenant between the people of Israel and God. And there are biblical scholars who say it came up in a very particular historical context. When the Assyrian Empire ruled what's now Israel, and the people of Israel wanted to not be ruled by a foreign kingdom, and so they replaced the idea of fealty to an overlord with fealty to a law-giving God. And when I read that last year, because I don't pretend to be a biblical scholar, I was struck by the sentence we all know from the Declaration of Independence, right? That we hold these truths self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and among them life, liberty, and the pursuit of happiness. Now, in the new musical Hamilton, there's a female character who says, I'm going to go to Thomas Jefferson and tell him to write a sequel where he includes women, which is right. But this notion that there are some things that are so important to us that they precede government, that they should govern government, is, I think, fundamental to the unique American experience in creating our rule of law. And I think these principles of equal protection, of protection of fundamental rights, and of case-by-case adjudication, to me, are all at the heart of the question of rule of law.
Well, honestly, that was really well stated, and I appreciate that. I confess I go to Torah study once in a while, but I don't have anything to add that I'm afraid wouldn't be challenged back if I started to comment on Deuteronomy. So that was very good. Look, so I want to ask you this. As part of your role as general counsel, of course, you have to be an administrative law scholar. Yeah. To me, part of it has to do sometimes with process and with how you conceive of administrative law. So you have the bird's eye view of this. What one process reform, do you think you could name that would improve? Just take it as a given that it would be a good thing to improve the collegiality. Is there any process reform that could be implemented by Chairman? I mean, let's be honest. Chairman Wheeler is the one to do it. With your advice, what could be done?
Well, I think I think these policy questions are for the commissioners, not for staff like me. But there's one that does require Congress that I think goes to collegiality, and I would like to address. And that is the proposals to make some changes to the Sunshine Act so that commissioners can deliberate, so they can talk to each other more directly, right? There are some proposals on the Hill, for example, that would allow, if I understand it, a majority of commissioners, so long as they're not of one party, to talk and have a record made of that conversation. I really believe when people talk face to face, their understanding improves. Their understanding improves about where they're coming from sometimes because they're tested. Their understanding always improves about where the other person is coming from. I think more direct conversations between commissioners would be a very helpful step in improving the deliberative process of the commission.
Okay, well, I have actually been a long time supporter of changing the Sunshine Act, and I've written about it and all of that, and actually served on a committee of the Administrative Conference of the United States that made a recommendation to change it. But I'm glad you brought that up because, and you talked about understanding, increasing understanding among the commissioners, but also among the public. And look, so one of the issues about process that's received a lot of attention, Commissioner O'Reilly has brought this up mostly, it has to do with releasing the text of orders before the vote so that the public would know what's before the commission, what they're voting on. And actually, the Administrative Conference of the United States, and I was on a committee that recently reviewed this, there is a recommendation of ACUS, I know you're familiar with the Administrative Conference, that basically says, in effect, that to the extent possible in advance of sunshine meetings, this all has to do with the Sunshine Act and how the Sunshine Act operates, that it's useful for the public to have all of the memos and so forth, materials related to that item the commission's going to vote on. Tell me, I know that hasn't happened. I know Chairman Wheeler's resisted it, but again, this is in your bailiwick. Just tell us briefly what the argument is for not releasing the draft items so that at this sunshine meeting where the public is listening in, they know what's being voted on.
Well, let me talk about, I think you and I both appreciate the fine work that the Administrative Conference of the United States does. So I went back, I think you're referring to a 2014 recommendation. And part of it says materials ought to be released except for those documents that may be exempt from disclosure under the Freedom of Information Act. Now this is very important because, as everybody knows, the Freedom of Information Act in its Exemption 5 protects the disclosure of materials that fall within what's become called the deliberative process privilege. And the deliberative process privilege has been recognized as being very important. For example, the Department of Justice guidebook on FOIA talks about this in terms of encouraging open and frank discussions of policy within an agency, protecting against premature disclosure, and protecting against public confusion that might result from disclosure and rationales that are not finally the grounds for decision. I think deliberation is important, right? The Supreme Court in this context talked about the importance that the fear that officials will not communicate candidly among themselves if every remark is subject to civil discovery or might end up on the front page of a newspaper. I think one should take the deliberative process important. I think Commissioner Rosenworcel has said it very well. We need transparency and we need deliberation, and the commissioners, not staff like me, can figure out best how to strike that balance. But I do think in the context of this ACUS recommendation, we should recognize the importance of providing space for deliberation for the commission.
Actually, I think it might be a different recommendation that I have in mind, but we're not going to resolve it here. This was one that dealt with best practices under the Sunshine Act, and I think did suggest that materials like the draft items could be made available.
But Randy, that is the sort of the quintessential example of documents that courts don't order that courts find subject to the deliberative process privilege are things like draft items, those kinds of drafts.
Yeah. Okay, well, let's delve into that further at the next conversation we have.
Okay.
Because I want to get a little more into the substance of a couple things. And so I want to talk about the open internet order. And again, I commend you on the argument you made. And there are lots of different issues here, of course. But I want to focus on the process in this one respect that everyone knows is important. And it was the subject of a inquiry at the oral argument, a line of inquiry really, and that has to do with President Obama's involvement in the proceeding through the video and statement, and then obviously it's now come out just recently. I think it may have been intimated anyway, but that there was a change that took place rather abruptly. There seemed to be some staff confusion, if you believe the emails that were released, and a switch-in course, and of course there was no notice, no further notice about the change in course. So you take that, and I want you to, just going to ask you, John, to talk about that involvement and how that relates to your understanding of the FCC and your view as an independent agency. I remember at that oral argument, I remember Judge Tatel, I think he was pursuing it, and he got to a point where he said, I want to ask you to give your, quote, crispest answer, I think he said, as to why the FCC abandoned its proposal to rely on Section 706 rather than Title II.
So this is, people may know, this issue, the open internet case, is still in litigation. So I want to limit my comments to what we've said to the court. What we said to the court was very straightforward, which was totally appropriate for people to make their views known to us. That included millions of Americans. It included many members of Congress, both parties. It included the President of the United States. And as we explained in our brief, the comments of the President were filed with us entirely in accord with the Administrative Procedure Act, and therefore were appropriate as a matter of process. Look, it was you and I have already talked, and you were very kind to me at the day of the argument. I had not done an oral argument in a long time. And I will say I prepared a lot for this argument. It was a really interesting experience. I thought all the lawyers did a great job. I thought the judges asked a series of very, very helpful questions, and it was a privilege to argue it. And whether I did a good job or bad job, that's for other people to assess. But for me in my career, the chance to be in court that day was a considerable honor.
Okay. Just to be clear, I think I said this earlier, but I don't want, what I said to John, I did it a couple times, and I really meant it. I thought he did a fine job, but I think I did add, I hope you lost, right?
You did say that.
Okay.
You did say that. And I said I appreciated the first part of your compliment.
Right. That is all true. Well, look, let's stay with the open internet order for just a minute, and this goes more to the substance, but you alluded to it earlier when you were talking about the common law and that approach, and I really appreciated the depth of that answer, really. So I was digging around. This was actually just 2 days ago, and I found, because I've always kept up with your work, tried to. So I found a paper released in November 2011 titled, quote, "The Internet Ecosystem and Legal Regimes, Economic Regulation Supporting Innovation Dynamism." And, I looked at that. And I just want to quote from it because I found a lot there to like, and then let's relate it to the current things. You said there, without, and a lot of it had to do with, I think all of it mostly had to do with regulating, broadband providers. You said, without preemptive regulatory intervention, the market will tend to provide numerous benefits in innovation, price, and general consumer welfare. Moreover, the boundaries of the internet marketplace are not sufficiently stable for regulation to have a reasonably predictable effect over time, which should be a prerequisite for predictive rulemaking. Because rulemaking may incorrectly predict the source or extent of those benefits, the risk of stifling competition and innovation is not worth taking in the internet marketplace. Adjudication in a more common law approach that can learn and respond to the developing internet marketplace is better suited for policing competition in that space. I thought that was really a nice statement, but it seems really to me so much at odds, frankly, if we can be candid, with the approach taken by the Commission in the Open Internet Order, where it established these bright line rules, no paid prioritization and so forth, as preemptive regulatory intervention. How do you square what you wrote there with what the Commission did?
So, my background before I came here was that I was doing a lot of antitrust law, and so I tend to think of antitrust as a metaphor for this. And what one wants to do is to understand the extent to which facts matter in a particular setting. The more we know about something, the more we may feel confident that we don't have to go into a detailed factual examination. So think of three categories. There are times where we feel so certain about the effect of a practice that we feel the most efficient way is to give people guidance and identify the practice. In the antitrust world, that's the per se rule against price fixing, right? We don't need to have a big factual examination about two CEOs who compete against each other having conversations about fixing prices. In a similar vein, the Open Internet Order says there are three practices: blocking, throttling, paid prioritization, where we've been looking at this, really back to the 2005 policy statement from the Commission, and we now understand enough about these practices that we can give specific guidance because we understand the facts and we've thought about them so long. A second category, and I think you're going to come to this, but I want to talk about this, is sometimes we know a lot about the facts, but we don't feel we know as much. And that's the world of rebuttable presumptions, right? The Commission last year reversed the presumption about whether there's competition in local cable markets because of the now ubiquitous presence of DBS. So the Commission said, look, we used to have a presumption against competition. Now there's a presumption that it actually exists, because as we look at the facts, it's a good enough starting point, but rebuttable presumptions can be, by definition, rebutted. Maybe there's specific facts on the ground that take us a different way. Then the third category is sometimes we really understand that issues are in flux and that we need to know more. And so, in the Open Internet Order, the Commission, for example, in what's called the General Conduct Rule, decided that its state of knowledge and change in the marketplace was swift enough, with its understanding of the state of affairs not yet established well enough, so that it was important to use the kind of common law case-by-case approach. This strikes me as a very intelligent design of a system. Where we have certainty, then we can give guidance, and that creates efficiency. Where we have a basis to start our analysis, then we can adopt a presumption, understanding it's rebuttable. And where we are at the beginning of a learning process, then we look at the traditional American approach of common law. That's what the Open Internet does, and I think it's a very, very reasonable approach.
But you'll concede, I assume, that there's a large area of activity that contrary to, sort of the mantra that came out initially about establishing certainty, where the order really creates uncertainty because of this general conduct standard. I mean, you've got these zero-rated plans and sponsored data plans, and there's a lot of experimentation taking place. And Chairman Wheeler at one point said binge on seemed, I think he said it looked to be highly innovative and competitive. And then, but nevertheless, the providers that offer those plans are now subject to some type of inquiry. I know it's not a formal proceeding. Don't you think, in light of what you had written earlier, really, that does have the possibility, or maybe even probability, of chilling developments in the marketplace?
I don't think so. The chairman has talked about the importance of permissionless innovation, right? Permission means one has to ask before one can act. In none of these circumstances did anybody have to ask before they acted. In fact, in each one of them, they acted. People brought new products to the marketplace. Now, the commission is an expert agency, and it remains expert by understanding what's happening in the marketplace. So the chairman has said he's asked policy bureaus to understand what's happening. That seems to me what one wants in an expert agency. But the fact is, in these instances, there was permissionless innovation, and the innovation has reached consumers. And by the way, how it plays out in the market provides greater understanding to the commission, and I think everybody else in the ecosystem.
Okay, God, I know, in theory, or in reality, we could go on forever, but I know your time's valuable, and I'm just going to ask a couple more questions and let you go. But you'll have to promise to come back at some point in the future.
Sure, of course.
So let me, I'll ask, you mentioned, I think that you and I had talked about the use of presumptions by the commission, and you gave an example. And I for a couple of years, I have been trying to urge that the commission adopt that approach, given that whether we agree on to what extent and how quickly the market seems to be moving in a more competitive way. And you did that in the cable, with regard to the cable systems. And God, this isn't even a question. I just urge you to think about using that more. But I will ask this question. You've got this special access proceeding going on. Is there any statute of limitations to how long a proceeding can go on at the commission? No, that's a trick question.
That's a good question. Does anybody have a copy of the communications?
Don't answer that. It's been a long time, but here's what I wanted. Two things here. Number one, if I understand this proceeding correctly, and it's not one of the ones I've followed as closely as some others, but I do believe the commission is asking for information really on a building by building basis almost across the country in terms of what services or whether services are being offered. Now, you talked about your antitrust background and your approach to markets. How in the world can a market, how are you asking, why are you trying to collect information on a building by building basis?
Well,
is that the market, I guess, is what I'm asking?
The commission hasn't ruled that that's the market, to my knowledge.
But have you asked for information on a building by building?
Sure. Look, suppose we were going to do study of consumer products, right? Diet soda. We want to know if it's a competitive marketplace. We'd ask about individual consumer transactions, right? Were consumers buying diet soda? Who were they? How many were they buying? Where were they located? What products seemed to be substitutable for diet soda? The fact that we were asking about individual consumer transaction would not make every consumer a market. And so here, we are asking for information about how the market works, including where facilities are located. But we've not made a market definition decision. What we have done, and the staff of the Wireline Competition Bureau is working very hard with the help of very useful comments from people who don't necessarily agree, helping us understand the market so that we can begin to think about, or we can think about, the definitions of product in geographic markets. It's a very fact-based review.
Okay, I just want to say, because I know you appreciate this anyway, but it's important, I think, for people to understand. It's sometimes missed. In the past couple of weeks, I saw a pleading filed by NCTA in the special access proceeding, and it's a competitor. Again, we can argue about the extent of, but it wants to compete in, what you call the special access market. And it was making the point basically, seemed to be pleading with the FCC, not to regulate in markets in which there was one other provider, and it was actually pretty explicit. It said the reason is because if you force down the rates of the ALECs, you're making it harder for emerging competitors to compete, and a lot of times people don't understand that dynamic. They think if you're a competitor, you want to see the other guy regulated. So I know you appreciate that as well.
Look, I mean, it's one of the questions about market definition that are in this proceeding, right?
Right. Okay, so the last question, and this will be another softball like we started off with. I just asked about the muni broadband preemption thing, just to help us understand,
Yeah.
not even the substance of it, but we talked about that earlier. But I mean, can you tell us why the Department of Justice refused to join the Commission's brief defending your decision? And then the second part of the question is, if you happen to lose that appeal, we obviously don't know what will happen, but I'm just, I was never clear about this or have forgotten it. Can you, without the Solicitor General, can you take that case to the Supreme Court?
Yeah. Look, I think that first question is better addressed to the Department of Justice. I'm not sure I'm in a position to know the answer.
They didn't tell you anything sort of off on the side or anything?
I think that the Justice Department's should have the ability to explain its own decisions. And I'm not going to indulge in hypotheticals, but look, the issue here is a very straightforward one and an important one. We have two state laws, one in North Carolina, one in Tennessee, that, in the Commission's view, impair the federal interest in broadband, which is an interstate communication. It is interstate commerce, over which the federal government has jurisdiction and over which it has made competition policy choices. And the Commission found in these instances that municipal utilities that were operating successfully were being unfairly barred, inconsistently with federal law and federal interests, from providing broadband to citizens who wanted it, including, I think, in Chattanooga, which has been very successful in its system, from providing broadband to people who had no other broadband, had none, had zero. And so the Commission order explains, and this was recently argued, I think, on St. Patrick's Day,
right,
in the Sixth Circuit. A very good lawyer from OGC, Matthew Dunn, explained to the court, this is a federal interest that we believe supports the Commission's actions in preempting these two state requirements.
Okay. Well, I appreciate that. And in just a moment, we're going to, I want to ask you to join me in thanking John, but I'm just going to tell you what's going to happen the rest of the day here. As soon as we get through, then the panel's going to come up on the rule of law and continue that discussion with Ambassador Revere and Bob Quinn and my friend Danielle Lyons from Boston College Law School. And then right after that, one of AT&T's senior officials, Glenn Lurie, is going to give a closing keynote. But look, what I want to say is I thought this was really terrific. I learned,
Well,
I learned a lot. I'm sure people in the audience did. I think you and I could continue to have a great discussion about Deuteronomy and the rule of law and things like that.
I have extra index cards on that if you want.
Yeah. Now you were really well prepared. But I knew you would be. But it was very, I think, interesting and lively. So I want to thank you for it, and I want the audience to join with me.
Well, thank you, Randy. Thank you. I appreciate the chance to be here.